good morning, good afternoon, or good evening, depending on wherever in the world you are. On behalf of Department of Law, North South University, it is my utmost pleasure and privilege to welcome you to this webinar on human rights norms from below. Our guest speaker today is Professor Adanan A. Zulfiqar of Rutgers Law School. But before I introduce him and invite him formally to deliver his talk, it is my pleasure to invite our department chair, Barrister Arafat Hosen Khan, for his introductory remarks. Arafat, over to you.
Thank you so much. Thank you so much, sir, for giving me the floor. Today's distinguished guest, Professor Adanan A. Zulfiqar, like our host, Rizwan sir, our other guest, and of course, our beloved students. Good evening from Bangladesh and good morning, afternoon, like whoever is joining from outside Bangladesh. I'm very honored to welcome our guest today at the Department of Law University, North-South University's webinar on human rights norm from below. Today we have the privilege of hosting a very distinguished guest, Professor Adanan A. Zulfiqar, Associate Professor of Law at Rutgers Law School. This event signifies our commitment to fostering meaningful discussion and promoting awareness about crucial issues in the field of law, particularly those related to human rights. Human rights are a concern of our modern society, and their protection and promotion are of paramount importance. This webinar offer an opportunity for us to discuss into or to dive into the evolving dynamics of human rights norms and exploring how they manifest from below. Professor Zulfiqar's expertise and insight promise to enrich our understanding of this vital subject. I'm not taking much time. Again, thank you everyone for joining, and I hope our guests will listen to the talk and also engage to get their knowledge enriched. Thank you so much. Thank you so much.
Thank you, Arafat, for your kind remarks. I would now like to invite Professor Zulfiqar to deliver his speech. Adnan, please.
Thank you. So I want to begin. Assalamu alaikum. Shurute ami shubaiki amar antorik shubekcha janete chai. That is my best attempt at speaking Bangla, which I'm grateful to my brother-in-law for providing me, and I hope I did not embarrass him too much with my pronunciation. One day I hope I can give the whole speech in Bangla. I'm delighted to be speaking with you all. I think the only thing that would delight me more is if I was giving this in person, as Bangladesh is a country I've wanted to visit for many years now, and hope to, inshallah, do that at some point in the future. My talk today is, I'll give you some background of it in a moment, but it's really going to be for about 25-30 minutes or so, and then I would really like to turn over and engage you all in questions that you may have of some of the ideas here, or with human rights norms and more broadly. So I'm hoping that we can turn it into a conversation as well at some point where I can gain from you as well. So let me, with that, share my screen. I'm assuming everyone can see that okay. Okay. So how did this project come about? I think it's always good to discuss one's origin points with regard to ideas that you're putting out into the public space. And I think some of that may give you a sense of the directions in which I go. There are really sort of three main places that this project comes about. The first is some years back, almost now it's been close to, I would say, over a decade or more. I ended up engaging in a project to help the Maldives codify its criminal law. And there, the project involved, it's a long project, I've written on it, and so you're happy to sort of explore that. But the key component for the purposes of this paper was that there was a synthesis that the Maldivian government was seeking between their sort of Maldivian law that they had developed, which was kind of taken from a variety of different places, indigenous as well, but also taken from the Indian Penal Code and other places. There was their international treaty commitments that they wanted to make sure that they were in line with. And then there was the idea of Islamic law that they wanted to fill in the gaps with. They wanted a comprehensive criminal code that was going to be in line with Sharia as well, right? Which was for them as a Muslim country, an important part of their indigenous legal landscape. Now, conflicts certainly arose with Islamic law and their international treaty commitments, but there weren't necessarily as many as they had thought. But this project, this exercise of sort of seeing where laws that are indigenous, laws that are present in a society, and international law and international norms became part of the intellectual exercise for us as we were drafting. The second thing that ended up happening was the Arab Spring, where what we observed, or I observed as I was thinking about it and writing through it, was all these progressive, secular dictators, very Western aligned, some of them, not all of them, doing work as it relates to women's rights and minority rights, etc., that all these social reforms ended up seeming almost meaningless in the absence of political freedom. That there was sort of this moment in time where, despite all these potentially, you could say, very progressive and internationally aligned human rights norms that had been introduced into these societies, that in the absence of political freedom, they ended up amounting to very little in terms of motivating people to say, hey, no, we should still keep these folks around. And what I saw in my study of the pro-revolution or pro-Arab Spring discourse among jurists who work on Islamic law in particular, so Muslim jurists or scholars, if you will, ulama, fuqaha, however you want to say, I saw these creative, innovative ways in which they were trying to integrate human rights with Islamic law, right? And integrate some key ideas in order to make the revolution, this protest, authentic. And the key question they kept asking was this idea of, can we protest, right? That's what, the key question that people were asking and that these jurists began to explore. And then finally, the third component was an interesting gathering that I was a part of many years ago in Austria, in Salzburg. And it was a gathering of experts of international law, but then also lawyers coming from a variety of different countries in the world, in the developing world, who many of them were either from Muslim majority countries or in countries where Islamic law played some role in the legal system. And it was an interesting gathering because, you know, there are all these experts, they're in this room, and they were trying to discuss the role of international law and Islamic law in the legal landscape internationally. But what I noticed was that there was an overestimation of the reach and power of international law relative to Islamic law that was existing in that gathering. One of the stories that I tell in my article on human rights norms is of, a certain point in the conference where one of the leading UN officials, there had been disagreement about certain things related to human rights, other parts of international law as it relates to Islamic law. And he made this statement very kind of innocently to say, well, at least we can be in agreement that at some point we should have a set of international norms on human rights that we all are going to fall under. And what people took exception with for him was that the assumption was that international law would dictate what that universalist posture would be, and nothing else. And like many other sort of domestic jurisdictions where, like the United States, for instance, would, while they respect in certain quarters at least international law, they wouldn't imagine it being above American law. Many of these individuals from Muslim majority countries took exception to the fact that international law should somehow supersede Islamic law. And in the process of this type of misunderstanding, at least about the role of Islamic law in society, there was a missed opportunity for areas of congruence and all that, right? So all of that, I know I'm sort of using Islamic law as an example, and I'll come back to it at a certain point, but all of this raised the question for me as to what is the best way to promote human rights and human rights norms in society. What is the best approach in doing this? Some of the key ideas that then came up for me was, okay, in order for me to understand the best way to approach human rights and human rights norm diffusion, I need to first take a look at what the current approaches are to diffusing, to spreading human rights norms. And I relied on the research of Ryan Goodman and Derek Jinks as kind of an example of the three main approaches that exist out there. And the first one is this notion of material inducement, right? Where countries in the world, typically obviously those with material resources, so financially wealthy ones, will give financial incentives to other countries for them to improve their human rights regime in their country. And they'll either give those incentives or they will take away certain financial incentives if people are not sort of moving along in terms of human rights. So that's one approach. The other approach is the idea of direct persuasion, the notion that you try to convince these countries that, hey, it's better for you to do human rights or promote this particular human rights norms because of X, Y, and Z reason. And so you sort of try to reason with it and have that type of discussion. And then the final is something that's known as acculturation, where a country is part of a regional bloc or is part of a grouping of other nations, and the behavior of those other nations as it relates to human rights and sort of promoting human rights in those societies, that almost in a way like peer pressure, this other country will acculturate, will start adopting those norms because of kind of the influence of the countries around them, right? So those are sort of in very general terms, these approaches. But I saw these approaches as having some positives, certainly, but crucial flaws. And for me, the two main crucial flaws were the fact that these were entirely state-centric approaches, that they essentially ignored the society and people where human rights were going to actually live. They operated on a key assumption that state-level adoption of norms will allow greater penetration of rights in the underlying society, right? That you adopt norms at the state level and that that will just filter into society, and then society eventually will adopt it, and you'll have a more sort of just, more human rights-based society in the long run. And I found that assumption and that sort of that key assumption to be quite flawed in the reality that I observed through my own research. The second was that I found, similar to what I think was the crucial problem with the conference with the UN officials that I described, I found that there was no attention to even the idea of alternative universals. The idea that the sort of only challenge that's coming to the international legal order comes from other domestic legal systems that are very local and particular to a particular society or a particular country. What I find in these approaches, and what I found in those discussions with these international legal experts, was that there wasn't an appreciation for the operation of other transnational legal regimes, other legal regimes that have some claim to universality, right? The example I use is Islamic law, because that's the one I know best, but there are other ones that are certainly out there, right? But the notion that Islamic law, while it conceives of itself as applying to Muslims, what it lays out in sort of its framework, its value system, is a vision that is global and universalist in posture. To some degree, has to be, it's a proselytizing faith, etc. Christianity has similar notions, even though its legal system is not necessarily as robust, right? But the Islamic legal regimes, or the Islamic sort of legal conception, in many respects, is transnational. It's not sort of just localized domestic legal system, and if it's treated in that way, there's a real failure to understand, I think, how you can diffuse norms in these domestic contexts in these different countries. I take sort of some inspiration from this Kenyan thinker, philosopher, writer, Ngugi wa Thiong'o, who says that, he points out that one of the major challenges with colonialism was that the colonialism failed to realize or failed to accept that knowledge begins where you are. But what it ended up doing was conditioning the colonized into thinking and acting as if the journey of knowledge begins in imperial centers, right? And so for him, he's pointing out what I think in many respects is part of the conditioning that's ended up happening with international law, the notion essentially that knowledge begins there and not here. And that was something that I felt was baked into some of these approaches. What's the consequence of this, though? All right, you say, all right, Professor, you're saying all this, but what's the consequence? The consequence for me comes down to fundamentally the idea of the durability of the norm. We don't just need concern for if human rights exist, but we need concern for whether human rights can persist in a particular context. Can they last there? Are they going to be there beyond just the particular moment, right? And in order for a norm to be durable, right? So this is what I call the durability of norms, the durability, the ability for human rights norms to persist in a society. In order for norms to be durable, they require reception within the population below, the population that exists, that society has to be able to receive and take those norms and embrace them. For that to happen, the norms must have moral credibility. So the two key issues that are consequences of, I think, these flawed current approaches are that They fail to account for durability of norms, and hence they introduce norms into society that I don't think are always that durable. And two, they fail to appreciate the role of moral credibility, and as a result, again, the population is not necessarily as embracing of them, even though they may be embraced by the state structures. Which goes to then that first point for me, is that these are overwhelmingly state-centric approaches that are focused on top-down measures and top-down approaches to bringing human rights to society, right? And so that then raises key questions, two larger questions for me, right, that relate to context and relate to the choice of rights that we decide to promote and diffuse. Does it matter, for instance, whether authoritarian regimes adopt human rights? Does it matter which rights are adopted first, right? Those, I think, and obviously my answer to those, based on my paper, is that yes, those things matter. I don't think that they're accounted for when we do norm diffusion, but those things matter. So the answer for me is yes. And in fact, I locate the three detrimental trends in human rights norms promotion as it is currently pursued within autocratic contexts, right? The first idea that I look at is this idea of norm imposition. The current strategy pushes the norm preferences of foreign actors, mainly Western ones, on the rest of the world. Part of this strategy is the pushing of socio-cultural norms, specifically ones that are pertinent to the values of much of the Western world, or at least pertinent and relevant to the values of the Western world at this particular moment. I'll give you an example of some of this. I was working for a period of time on the sort of situation in Syria, the conflict that was ongoing there, and as part of this sort of rebellion against the autocratic rule in that country. And in that situation, there were these local councils that were being established in various sort of towns across the country that were opposition groups that were trying to govern in opposition areas, while also kind of helping to lead the fight against the regime. And these were coordinating councils that existed. They were reliant on funding from outside parties, which was understandable. But the interesting thing for me was, in the course of the conversations, the funding would end up being stuck up on the fact that, well, we need a commitment to pluralism and diversity in these councils. What did that mean? Well, we need the councils to represent the tapestry and diversity of the Syrian people. We need Alawis and Druze and Christians and men and women and Sunni and Shia and everything as part of these councils, every council, before we give funding. Now, ostensibly, great idea, right? Yes, sure, diversity is a wonderful value. But at the time when bombs are falling and when people are scrambling to just put together some semblance of governance so they can organize society, the imposition of these type of human rights norms on a context that was in a very different place, for me, illustrated this tendency for international priorities to be given weight over local ones. And 2 points emerge in particular. There is a notion that all rights are equal, all human rights are equal. And that is simply not true. It depends on the context. For many contexts, where political freedom is absent, there is primacy of the political, right? Going back to my earlier point, all these regimes that had promoted so many sort of human rights norms ended up, at the end of the day, in the absence of political freedom, those norms and that promotion of sociocultural norms ended up amounting for very little. The second trend that ends up happening, in my view, is what I call norm bargaining. And this goes back to this idea that I mentioned of not all rights being equal, that some rights are simply more consequential, and specifically political rights, ones that challenge state power. So look at the case of Saudi Arabia, right? 2017, they lift a driving ban on women. And there's a lot of fanfare around it. It proclaims, some places were proclaiming the new dawn in Saudi Arabia, and they're gushing op-eds in Western newspapers. MBS is the sort of crown prince is declared as a major reformer. Meanwhile, human rights activists that had been protesting for the lifting of the driving ban for years, if not decades, were jailed, and some kept in jail for years. In fact, they were rounded up a few weeks prior to the announcement that the ban was being lifted, right? So what was that illustrated of? For Saudi Arabia, allowing women to drive was not as consequential as giving them political voice. The right to advocate for change was more threatening than the change itself. And these type of norm bargains that I call are what certain states will do because of the type of approach we have to spreading human rights and promoting human rights in the world. Finally, the third trend that I notice is what I call norm tainting. And this suggests that in the current state-centric approach, there's actually potential for detrimental impacts on human rights when they are done in autocratic states. It's the notion of guilt by association, which can taint an important norm by attaching the ill will associated with authoritarianism. People are unable to always separate the dictator from the dictate, right? So if we look at Somalia and Egypt, let's take them together for the sake of time as two case studies. Both are scenarios where you have two secular dictators, Hosni Mubarak, Siad Barre. As part of their agenda, they pursue incredibly important women's rights reforms, right? But with little societal input, right? And I can go into detail of even how Suzanne Mubarak, who kind of led these approaches in Egypt, essentially undercut all the women's rights organizations in the country because she sort of wanted to be the leader of it and be the one who's associated with bringing these norms. As a result, these norms ended up having an association with the authoritarian regime, such that many important women's rights reforms that occurred began to be known as Suzanne's laws. And that people would, after Suzanne Mubarak, and that people would reject them as being part and parcel of this regime that has been oppressing us. Likewise, in interviews that Mark Fatih Massoud and others have carried out in Somalia, Somali women's rights activists want nothing to do with the legacy of Siad Barre, because in the process of promoting his reforms, he also ended up executing a variety of religious clerics, taking stances against Islamic law, and the reforms began to be seen as anti-religion because the dictators were seen as anti-religion. And for the human rights activists in each of these contexts, that simply would not allow those norms to have any longevity within these societies. So, what might the solution be? For me, the solution and my intervention is to push for a human rights approach that begins from below, with people, with society. There's a need to indigenize human rights for them to be durable and to have moral credibility. The process I propose we focus on and find synergies with is what I call enculturation. And it's really a product of ideas that come from sort of the notion of vernacularization, the ideas of empirical desert in criminal law and other places. But it's this concept that I've sort of tried to craft. There are three main components to it. The first is the idea that enculturation is a process that exists below, in a society below. And what happens there is that those societies go through this step where when a norm is introduced, its substantive legitimacy is initially assessed. Societies filter out norms that do not align with their values at that moment, right? So that is the first step with regard to moral credibility. The second is the notion of local vernaculars. The language of human rights is important. The sources that we reference to support human rights are also important. The manner in which they are framed is important. But if we do all of that in the language just of international law, we are going to fail to reach the society below, and for the society below to understand and appreciate the value behind the human rights norm we're promoting. Local vernaculars, and by that I mean the local languages, the local sort of, and not just languages like Bangla, but what I'm talking about is languages of law, like Islamic law, right? And that those vernaculars carry with them an entire ecosystem of values and tradition that lend itself to moral credibility. And then finally, in promoting norms, we have to look below and we have to look at civil society and the trusted messengers within civil society. There's a need for native agents that have pre-established credibility, who can convey these norms to people, and it will be trusted. These norms will be trusted as aligning with the society's value because the individual who is bringing them is a trusted member of that society, right? Is someone with pre-established moral credibility. And here I am speaking to reaching and engaging members of civil society who are not always the ones that we look to first, but sometimes are on the front lines of very important human rights norms in society. And these are clerics oftentimes, as it relates particularly to issues of political freedom, right? But the idea of enculturation is that it begins with the premise that values and norms of a particular society are first and most fundamentally taught to them through their own context, not external ones. And for human rights norms to fully embed within a society, they must be perceived as emerging from within and not without. So let me quickly just mention enculturation as it exists in practice in one or two examples. Let me take, for example, the case of Nimr Nimr, a dissident Shia scholar, religious cleric, who was leading sort of movements in Saudi Arabia for the rights of Shia minorities, for political freedom in general, and broadly for a variety of other human rights. And he was both a religious cleric and leader of the movement. He eventually gets picked up by Saudi authorities. He's charged on a variety of different sort of terrorism charges and ends up being executed and essentially assassinated, right? But in the process, if you look at the sort of what he did while he was alive and the writings that he wrote, you can see that as a established moral authority, one that was using Islamic law as a local vernacular, right? Where he was able to articulate in his writings ideas that are present within the larger international human rights regime, but you articulate them using the language of Islamic law. He was able to embed many important values around freedom, dignity, respect for minorities. He's within the society. He went through a process, at least within his sort of society, of indigenizing those values because they had a level of authenticity. The same thing, I argue, happens during the Arab Spring, where Sunni jurists who historically had always aligned with the status quo, with the ruling parties, ended up in a moment of existential sort of crisis, if you will, deciding that no, they needed to articulate these rights that people were seeking for freedom, for dignity, for the ability to have some governance over their future. They needed to take these values that are present in the international human regime and not speak of them in international law language, but speak of them from within the tradition of Islamic law and connect it to people's past so that it has durability and some relevance for people's future. So those are sort of my remarks. I want to end it here. I've gone a little bit over than I wanted. I'm happy to take your questions, but I wanted to sort of end there and look forward to engaging your ideas.
Thank you, Adnan, for your excellent talk. And for the audience, the talk is actually based on his recent paper, which is published in Yale Journal of International Law. I have put the full citation in the chat box. You can have a look. Now, Adnan, the first question that I would like to put to you is, of course, you are talking about human rights norms from below, but within the treaty-making context, do you want to see any changes, any tweaks that human rights treaty-making process can somehow incorporate these values of norms from the below? Do you have any views on that? Yes.
Yeah, absolutely. So for me, I think the first step for many of these sort of treaty making and in the space of human rights norms in general, which we often kind of want to overlook because it's a longer process and a longer sort of stage, is that there has to be an effort to try to educate populations and societies before we bring them to sort of make commitments as it relates to human rights norms. And or even if we're doing it simultaneously, there has to be a more robust process of education. And what I think in the context of treaty commitments is that nation states should have some process whereby they are introducing referendums in their society that then allow folks to weigh in with regard to treaty commitments that the nation wishes to make. It should be part of, if a nation is going to make some major treaty commitment to human rights, let it be part of civil society discourse for a little while. Let it exist and let people debate in your society about it from different sides, and then potentially even have a referendum as to whether we should pursue this. We have to find ways in which we include the society below, even when we feel as though that society is not as far ahead on human rights as we would like them to be. And frankly, this is what exists in many of the developing nations. And they take as an assumption in the United States, for instance, that they are going to have to sell any treaty commitment they make to their population before they can truly make it. But their expectation when they deal with much of the rest of the world is, no, you buy into it, you agree to it, and then afterwards sell it to your people however you want, right? So that's where I would say we need to sort of reform our approach.
Thank you for that answer. My next question to you would be, as you have mainly cited, or the examples that you have given us are basically from the developing world or Islamic world, would this thesis hold for other societies, other kind of states in different contexts, or do you see different forms of this trend in other countries or in other type of jurisdictions? Thank you.
Yeah, so I think the same. So I use obviously the example of Islamic law because that's where sort of I have greatest familiarity and research. But as I've presented it in other places and likewise through sort of my own exposure to different types of legal sort of structures that exist or have historically existed in Africa, for instance, it has sort of salience anywhere, right? As long as in those societies, virtually every society, right, has had legal traditions that precede the advent of colonialism, right? They've had legal traditions that precede the presence of an international legal regime. And many of those societies are still tied to it, right? So even if you look in African societies, whether you're looking in places like Ghana, in other places in Southern Africa, etc., there are customary ways in which people are dealing with dispute, dealing with like sort of the type of rights that they feel should exist, that people are already doing this in some respect outside of the state apparatus. And my contention is simply that we pay more attention to that and we are more inclusive as it relates to those sort of traditions that exist within a society, and we are less focused on coming in from the top and imposing below. So I don't think that, I think Islamic law is unique in certain respects, of course, right? It's part of a product of a civilizational history that is quite extensive. But I think there are smaller examples you might imagine that exist in other parts of the world, in Africa, in South America, in other places, that are informed by those traditions, those countries' past traditions and indigenous ideas around law, and that those need to be empowered if we are, and many of those, mind you, many of those indigenous sort of traditions will have resonance with the types of human rights that we're interested in promoting. It's just oftentimes not the language in which we do the promoting.
Thank you, Adnan. The next question that I would like to ask you is from one of our undergraduate students, Masroor Jawad. His question is, in a bottom-up approach, wouldn't there be conflict between what different cultures and groups of people consider moral? Different cultures or states would likely end up having differently framed human rights that are not universal. So how does your approach address that?
Right. So I think that what we have to accept is that you're not going to have universal agreement on every single thing across the board, right? And I don't even think that the international human rights regime that exists today is asking for that necessarily, right? What they are trying to do in their attempt to come up with some universal framework is to point to things that they think will exist in every single society and that everyone will agree that we should not do this, we should not do that, right? And I think that the premise of that idea that, oh, are there going to be things that exist that we can all universally agree on would be a violation of human rights? I think, yes, certainly there are those things. When we worked on the Maldivian criminal code, one of the things that shocked most people who had never had any exposure to Islamic law was that how much of it was in congruence with many of the things that we were talking about in the American context, right? So there was within the Islamic legal regime, like and Islamic legal tradition, there were ideas as it related to ideas of sort of individual autonomy, ideas anti-corruption, certain notions of freedom, not necessarily in the pre-modern past as it related to political freedom, but other notions of freedom as it related to your ability to practice your faith, your ability to preserve the dignity of your family, your sort of rights as it related to your property. All of those things were present, right? Your rights as they related to your own life and protection of that. And I think those are consistent things that we might find in across the board in different societies. I think the other question that I'm often posed is that within a society, let's take Bangladesh, for instance, there's certainly not going to be one notion of what Bangladeshi like tradition is or what's part of the sort of past as it relate or part of indigenous Bengali culture. There may also be disagreement as to, oh, these things in our past, we should just leave them out, etc. I agree, right? But if we are going to argue that there's going to be disagreement within a society because of potential differences, then where is international law coming in, which is a foreign, external notion, right? That is going to, I think, have even greater hurdles. So the space that can exist within a society to help it work through and debate through, like, what are the values that are indigenous to their place, etc. I am saying empower that within civil society and not just sort of take ideas that are external and then impose on the internal in that way.
Thank you, Adnan. The next question is from Tarazi Muhammad Sheikh. Her question is there any test for durability of norms available in international legal instruments? If not, do you suggest any brief mechanism to determine durable norm?
That's a great question, right? And I think, no, I don't think there's any test as far as I can tell in the international legal regime, because I don't think they really care about it, if I can be frank. They are interested in introducing norms into societies, and then they'll monitor to see if that norm still exists, but they're not that concerned with its actual durability. For them, the measures will be, does the state still have it on its books? Is it still part of the legal infrastructure, etc.? But what I'm saying is that durability has got to begin in the first instance with its reception in the population, right? So how do you test for the durability of the norm? I would say you first have to go one step before that. Before we determine whether a norm is appropriate for a particular society, we have to really determine whether it has any substantive legitimacy there. That we have to allow that society to filter out the norms that are just not going to work for it at the current moment, right? And then let's say there's a really important norm that we have that we feel like should be introduced into a society. Then we have to go through a process of educating and hopefully getting that society to a place where they feel that there is resonance between that norm that we're trying to introduce and their values, their tradition, their cultures. I take political freedom as an example as it relates to Islamic law, right? Political freedom has really no no connection to the Islamic past. There wasn't political freedom, right? There was rulers, there were ruled. There wasn't political freedom as we imagine it now. There, the state as it existed was also not as intrusive. It is more decentralized, right? But as we imagine our political freedoms, that I should have a choice and who governs, that didn't exist. And yet, what's happened that we have seen in the 20th century, moving into 21st, is this idea of political freedom being interpreted, repackaged, and put into a form where it's articulated in the local vernacular of Islamic law, such that it is now sort of the very religious elements in society who are out on the streets seeking things, more representation within government, right? So for me, that's sort of the process that has to take place. Whether then, how do you determine whether that norm is going to be durable? The test is simple. Does it actually continue to exist in a particular society, be embraced by that society, such that now it is part and parcel of both the psychology, the embrace of that, and the language of that society's sort of rights and values. We can see how that's occurred in Western countries. If you look at norms that have eventually become durable as it relates, let's take the United States. The idea, the United States, a country which historically for centuries enslaved Black people, that are moving, I wouldn't say they've come completely to it, but have moved to a place of accepting the fact that, oh no, we have to embrace a multicultural society, that in fact our legal tradition, right, promotes that. Even though when you look back at that legal tradition, those are the same people, many of whom who had enslaved people themselves, right? But now those ideas are being reinterpreted into an anti-racist, a multicultural society. You can take the same thing as it relates to women's rights in the United States, other parts of the world, right? That the durability of norms, the test for it is the extent to which it survives in a society and then gets embedded within the values and the local vernacular of that society. That, for me, is the test of whether a norm is durable.
Thank you, Adnan, for that answer. The next questions, I actually would put two questions together. They are not directly related to what you have said on today, but I still thought that maybe you could answer one of them, one or both of them, depending on your choice. These questions are from Siren Azabi Saim, our undergraduate student. She asks, at this point of time, with the continuous human rights violations in Gaza, what form or forms of diffusion of human rights would be most useful and why? And a related question is also from her. Apart from holding a human rights violator accountable in international courts or through diplomatic questions, would you propose other forms of accountability to be ensured by the international plan? Thank you.
Thank you so much. I mean, so the question of, in terms of the first question with regard to Gaza, the question was, can you just repeat the first question a little?
Sure. The first question is, at this point of time, with the continuous human rights violations in Gaza, what form or forms of diffusion of human rights would be most useful and why?
Yeah, I mean, look, at the current moment in Gaza, obviously the space for any type of human rights norms diffusion right now is just not possible, right? And the reason it's not possible is it's not a priority, right? It's not a priority, I would say, for either side, because on one side, they have the state of Israel, which has overwhelming power here, has for the most part been able to historically balk at any type of international human rights norms as it relates to Gaza. I mean, it's a 17-year siege, but that wasn't even when I would argue that the actual kind of siege of Gaza began. That was maybe officially when it was, but Gaza has been controlled by the Israeli state for a long time. So we're dealing with a very different context there, right? Which is a context of occupation of one foreign power over other. So in many respects, one could argue that the sort of resemblance is less to a state where you have kind of a shared society and folks are trying to promote certain norms, but rather to a society that is very reminiscent of the dynamics that existed between the colonizer and the colonized. And I know people will balk at the notion of oh, this isn't that or whatever, or certain folks will. And I'm not saying it's necessarily an exact replica, but that it has far more resemblance to that than it does to some kind of shared society. Likewise, one may argue that in sort of even the rules of resistance, if you want to call that, that exist, or the ways in which to sort of approach sort of the whatever the Israeli state is doing, that there are sort of norms that govern that, and there are norms that govern that as it relates to Islamic law as well. But in this moment, the extent to which you can sort of create norms that are going to be durable and that people will hear you about, hey, like you can't go after non-combatants on either side, right? That you can't, no matter what your situation is. It's very difficult in this moment, I think, to promote that. If we are in a moment beyond that, I think what you have to go back to first and foremost for me in this context is the essential importance of political freedom, right? Promotion of norms without the presence of political freedom, for me, is almost always going to be a losing endeavor that has no real chance of durability. Like, so with Gaza, with the West Bank, if there is an absence of political freedom, which I believe that there is, true political freedom there and control over one's destiny, then it's very difficult to have discussions about other norms, because that's simply not going to be a priority for those societies. So I think that is the kind of central challenge there. The second part of the question related to, now I feel like I've talked too much, so I've forgotten that second part of the question, if you can remind me of that.
Sure, Adnan. The other part of the question was, apart from holding a human rights violator accountable in international courts or through diplomatic coercion, would you propose other forms of accountability to be ensured?
Yeah, so I mean, certainly I think there are other forms of accountability that civil society historically has tried to utilize when it comes to bad actors in the international stage that are not necessarily reliant on international instruments. And so that's where I would go, is I would go to two places. One is civil society, right? So the extent to which movements and people can mobilize to hold states accountable by doing what happened, for instance, in South Africa with the apartheid regime, and people deciding that, all right, well, we're going to have some kind of boycott that exists. And I know that in the Palestinian context, there's something similar that exists there, and debate over whether it's legitimate or not. All that aside, that is a strategy that exists, right? The form it takes, one can debate about, but that is a strategy. The other thing, though, so that's from the civil society standpoint and a movement standpoint, right? The other thing, though, I think that it has to happen is the extent to which regional blocs and groupings that are not part of necessarily the entire international order, but our regional blocs, that they begin to decide that, for instance, what's happening in Myanmar is unacceptable, and that in order for us to support violations against the Rohingya, that we are going to take steps as a regional grouping to cut off ties, to ostracize, to sort of end financial engagements with the regime in Myanmar, right? Or similarly, one could imagine with the Syrian conflict and the involvement of Iran and the Russians there, that there are ways in which regional blocs or regional groupings decide that that we will kind of punish at a state level in that way. Will that be effective? Maybe, maybe not. Is the ICC effective? It's not completely clear. At the end of the day, the international order is sort of a dream, a hope. Its effectiveness varies depending on where it is, but it's always limited by the extent to which powerful nations will rally around each other or will protect other nations. And we see that in the context of Syria. We've seen that in the context of Uyghurs in China. We see that in many contexts. I mean, Uyghurs in China have essentially been abandoned by everybody across the board, except for a handful of maybe nations. So, you know, that may not be a satisfactory answer, but that's unfortunately sort of all I have. But my encouragement is that civil society is not impotent here, that civil society has historically always been able to play a role, and that the success of that role doesn't come immediately, but is built up over long periods of time.
Thank you, Adnan. The next question is from E. Yuan. The question is, what are the possible impacts of the continuous development of human technology on human rights norms? Now, I know this is not what you have talked on, but if you have any thoughts on this, please.
Yeah, absolutely. I actually think that human technology, I mean, there's certainly ways in which it can be negative, right? Negative in the sense of the ability for falsehoods and lies to spread is much more amplified because of the type of technological advancements we've made, right? You can someone can make a story, you have no idea what the source is, they'll make a nice little video, they can doctor things, they can switch things around and then spread that everywhere, and people will buy into it, even at the highest levels of government or everything. I've seen that happen myself, right? That people will buy into it. So there's that fear. But on the other end, from the standpoint of what I have been talking about today, the notion that civil society and sort of promoting human rights from below, well, the very process of promotion needs mechanisms to do that. And technology serves a great purpose in that regard, right? And it potentially can amplify voices of individuals who maybe were only speaking to their immediate community, their immediate town or neighborhood, or even their city, that can amplify that beyond to stretch into other parts of that nation, or forget individuals, even ideas, right? And we see this in many ways. There's certain sort of human rights ideas that will then be articulated in some local vernacular, let's say Islamic law, and some little video will be made of it, and now everyone is spreading it on WhatsApp and forwarding it, etc. And that's becoming now and embedding itself as part of the value system of that society, if they accept the messenger who is speaking there, if they accept the substantive legitimacy of the idea, if it passes a basic test of that, and if it's articulated in a language that they feel is their own and is not necessarily a foreign one, right? And I think that international law, to the extent that, yes, many of us embrace it as our language to some degree as human beings, it's still one that in some respects we see as foreign. And part of that, I think, has to do with the power dynamics that exist as to who the crafters of international law are.
Thank you, Adnan. We are already out of time, but I would ask you just one last question.
I'll take as many as you
So
want.
if so, so if your skeptics would ask you that could diffused actors really create human rights as international law without any formal process of crystallization of those norms?
No,
How do you
sir.
respond to them?
Yeah, so my response is not, I'm not saying that the crystallization doesn't need to happen. What I'm saying is that there's a process that needs to occur that's before that. I'm saying that you're putting the cart before the horse, right? What I'm saying is what the key assumption is, oh, we crystallize it and then it'll spread into society. And I'm saying, no, I'm saying first, that idea needs to find its place in that society, be articulated in a language that society understands, be spread by people who are trusted in that society. And then you look to crystallize it at top. We have this model, which I call the 4 seasons model, right? And the 4 seasons model is this. You'll have international actors who will come to countries, not everybody, but I'm talking at sort of high levels. They'll come to countries to speak to the people there, the human rights activists, etc. But they'll be the ones who they can meet at the 4 Seasons Hotel and have a conversation with them over breakfast at the 4 Seasons Hotel. They'll likely be speaking in English, not in the local language. And that individual will hopefully probably have gotten some degree from a Western country where now they can be familiar with the cultural norms. They can have all that type of familiarity, right? They'll be very comfortable having that conversation and then feel that, oh, we've sufficiently talked to the local people on this. And for me, I'm saying that's nonsense, right? When I am in many, and I've lived in many different parts of the world for long periods of time, that's simply not where the values of society are being determined. Those are not the people you're talking to most of the time. A lot of times you're going to have to engage with people who are not going to speak in your language. Both literally, they're not going to speak English, and also theoretically from the standpoint of the language, the ideas that they are embedded in. And what I'm saying is that before any type of crystallization can happen that is going to have true value, you need to have this other process. You need to have this other type of engagement. And then, yes, certainly once it's there, then yes, we have to find ways to crystallize it. There's a legal system for a reason, but it will have greater reception and longevity when we do it that way as opposed to the opposite.
Thank you, Adnan. Thank you for that answer, and also once again for your excellent talk. I encourage our audience to read the paper. I have read it, and it is an excellent paper. Thank you all for your time. Have a good
Thank
day.
you so much. Lovely seeing all of you, and hope one day to meet in person.